I wanted to show you the badge from our conference. Judges and lawyers get together. We had a lot of criminal judges. And so the rule is you can't talk about current cases with the judges because that's not what we're there to do. So one of the things I want to talk about that was considered to some degree there is assault family violence cases and assault cases in general and what levels we have. All right, so let's start with Class C misdemeanor assault and assault family violence. You can have an assault that doesn't create pain or injury, and that would be a Class C assault. Also, you can have an assault that doesn't involve actually battery, where you actually contact or hit another person. You can have assault threat, where you say something that causes a person to have a reasonable apprehension that they're going to face bodily injury or an assault. If it's offensive or reasonably likely to be offensive, then that can be an assault. So if you knock somebody's phone out of their hand or a tray or something, it's typically going to be filed as a Class C. Now, the only difference between a Class C misdemeanor assault and a family violence assault is the relationship between the parties. If you have a roommate or a spouse, girlfriend, boyfriend, dating relationship, family members, those can be, you can have an affirmative finding of family violence made on the case when it gets to the end of the line. But keep in mind, a Class C misdemeanor assault is only punishable by up to a $500 fine. There's no possibility of jail time as a punishment. Now, there is a possibility of jail time on any of these cases if you start missing court, not responding. If you get a fine that you don't pay, then you can be taken back to jail on a warrant, and then to resolve that, you may end up sitting a case out in jail. I wouldn't recommend doing that because that is usually a conviction. It's always going to be a conviction if you sit a case out. And you don't want an assault conviction on your record, whether it's simple assault or family violence. It's better not to have that. There are consequences and cumulative penalties if you get further charges. So don't do that. Another thing to know about these, a lot of times if and when you get arrested on an assault case, there's going to be a temporary emergency protective order. So the judge will say, you, defendant, stay away from this person, the complaining witness, or the victim, as they say, and their address, and they protect typically an address. And if that's a place where you live with that person, well, you're going to have to stay away. You're going to have to make alternative arrangements unless and until that we can come in and talk to the judge and back that down and modify it. Another thing to keep in mind is when you call the police to try to get them out to quell your disturbance, quiet things, calm things, separate people, maybe get someone to leave, whether there's been just really serious yelling and arguments and anger, or whether it's escalated to pushing or violence or injuries. When they come out, they are almost always going to arrest somebody if both parties are still there. And sometimes it's more than two parties. Sometimes it's three or four. But if the combatants, so to speak, are still there, they will typically arrest one or more because they don't want to leave it, even if people have made up and are hugging and the tears are all through and everybody says, yeah, look, everything's fine. The police, they've seen too many times where they've had to come back pretty quickly with either a serious injury or a death. And so they'll arrest somebody, and sometimes they'll arrest who you think, maybe everybody agrees they arrested the wrong person. And that may happen. You won't always like the decisions the police make when they come out, though, because it may be you that made the 911 call out of fear, out of concern, and you may end up being the one that gets arrested. Then you get an arrest and you get a charge. There are ways to try to back out of that and get the person, their case dismissed. The primary way people do that is through what's called an affidavit of non-prosecution. And that works really well in municipalities. Typically, if there's never been a call of this kind before, a lot of times they'll just let that case go if the complaining witness says they want it to go. But they won't give you more than one shot at that in most places. And same thing goes for bigger cases. They typically when you start getting into Class A misdemeanor territory, it's not as easy to get them to let go of a case. It takes more time and effort and energy, and it's not a guarantee. So, and then the higher you go, the more that's true. The complaining witness is an important part in deciding what happens with any case. They will contact the complaining witness and say, hey, how do you feel about this? And then sometimes they'll make a realistic assessment of the facts and the circumstances and say, hey, we really don't have what we need to prove this case, and so we're considering doing A, B, or C. How do you feel about that? And so sometimes they'll talk to the complaining witness about what that person wants to be done, in light of the strengths or weaknesses of the case. And then also whether the person wants to testify, go through all that reliving of the trauma, however severe or light it may be. A Class A misdemeanor assault is when there's pain or injury, and the range of punishment is up to a year in jail and up to a $4,000 fine. Now, I've never seen anyone get the max on these cases, and I've been practicing 30 years, but nobody can rule out that as a possible punishment. The pain or bodily injury will get you at a Class A. Now, I have seen cases where the police won't file a Class A even though it's what the victim is claiming, because perhaps the story is a little shaky or they don't really believe in it, but they'll file a Class C sometimes in those cases. And it's almost a telltale that there's something wrong with that case and maybe there's going to be a defense built in there. Then up from Class A misdemeanor assault. Now, keep in mind, Class A misdemeanor assault carries up to a year in jail as a penalty, a possible penalty, and up to a $4,000 fine. That is the range of punishment, though most people who are charged with these crimes never see the full range. In fact, I don't think I've ever seen someone get the full year on an assault. I suppose if they were on a deferred and they violated their conditions of probation, then they could get the full year, and that may happen regularly in some places. But still, I haven't seen that happen where I practice. Going back to the Class Cs can only be a fine. You can't go to jail for a Class C. Now, you can get arrested and go to jail the night you pick up the charge, and that's how they get the charge rolling, is to take you into jail. But it's not the punishment for the offense. It's the arrest that's made and the booking and the charging. And then, of course, if you don't respond to the court setting or the notice to appear and you miss court and get a warrant out, well, then you can get arrested on that. And then you can even serve time on that. So even though jail time is not a possible penalty, it ultimately can be the outcome that happens on the case as a way of paying the fine. Now, I would say on any assault, you want to avoid a conviction, especially family violence, but really any assault, even at a Class C level, because these things will follow you the rest of your life and can have consequences if you get a second or third. And family violence assaults, they quickly start ramping up to felony level offenses, even if it's what would otherwise be a Class C. If you've got prior convictions, you could be looking at felonies on these. So worth being careful with. Now, above a Class A misdemeanor assault, you've got assault with previous conviction. So family violence assaults with previous convictions, that'll ramp it up to a felony level. And then also if you have assault serious bodily injury, those will be a felony. The other thing that's a felony is impeding breath or circulation. So this is a newer charge. It wasn't around when I started practicing, but they found that, in fact, we saw a statistic today at the CLE I just took the badge off from. If you've got an impeding breath offense, impeding breath or circulation offense, the victim of that offense is 750% more likely to be killed by their assailant than people who don't have an impeding breath case. They take those more seriously, and that's why they've instituted a charge just for that that's a higher level than just a Class A misdemeanor assault, because you can have a choking incident where the injuries don't look like they're felony level, and yet the person, her breath, or his or her breath, it's typically a female, but her breath was cut off so that she couldn't breathe for a period of time. Any period of time is dangerous. Of course, the longer it goes on, the more dangerous it is. So that's a separate offense. They treat that much more seriously. Now, if the person was choked but never had trouble breathing, well, then that doesn't qualify as that offense, and so it can be downgraded to a simple assault, because the remaining injuries on these cases, when you look at a victim of an impeding breath case, you typically are only going to have some scratches or bruises around the neck, which that's not a serious injury. It's the way that those injuries occurred and what the potential consequences of that action are that make it such a serious offense. If you have a situation where you're having a domestic dispute with whoever this person is to you, and it gets out of hand, and someone either gets assaulted, there's injuries, there's not injuries, there's yelling, there's fighting, whatever the level of aggravation and chaos there is, and someone decides to call the police to try to get this thing calmed down, or to prosecute somebody who's committed an offense, or maybe try to get the parties separated, whatever the reason for the phone call is, you can almost guarantee that when the police come out, they're going to arrest one or more people to try to clear the situation. They don't want to leave someone there on scene, even if everything's calmed down and tears have been shed, but everybody's smiling now and hugging. They don't want to leave the combustible situation in place by leaving both parties there. So they'll almost always make an arrest and charge someone with anything from a Class C all the way up to serious bodily injury or impeding breath. And then sometimes one of these assaults will escalate to an aggravated assault with a deadly weapon because someone perhaps brandishes a knife or threatens somebody with a knife. You don't have to actually stab someone to get aggravated assault with a deadly weapon. So a frying pan can be a deadly weapon. There are plenty of things that if they are brought into a domestic violence situation can have someone charged with something that's just short of attempted murder. A lot of the aggravated assault with the deadly weapons are the way they charge attempted murders. Now, that doesn't mean just because you pick up a frying pan, that's what they're thinking it is. But it does raise it to the same level of offense. The person who is the complaining witness in an assault can file what's called an affidavit of non-prosecution to try to drop the charges. And that's a lot easier to do in something like a Class C assault. But when you start having multiple calls and multiple charges, it gets harder to get that done. It gets harder to get the prosecutors to let go of a case because the complaining witness says, "Now, let's see, we're still friends, we're still together. Or even if you're not, I want to drop charges." And they'll typically do that the first time around. And then when you go up to the Class A level, it gets harder to do that. It can still typically be done, especially if there's no history, but it's stickier. It takes longer. It's not as quick and easy. So keep that in mind. And then when you get to higher levels, the prosecutor's pretty much trying to decide whether they can make the case without the witness testifying or without the witness's cooperation. And if they feel they can, they will keep going with the case typically. And so it gets even harder to let these cases go. And that's because they're trying to do their best job to protect the community, the complaining witness, and everybody. To get them to make a good decision in your favor if you're the defendant on a case, it takes more. They're not just going to let go of a case because I asked nicely. I have to give them real reasons to get something favorable as an outcome. I think there's some confusion among people if they have a dispute with a roommate and it's charged as family violence. They're like, why is that family violence? Well, it's because that's the way it's defined in the statute. People who have close relationships tend to get in conflict more often, and the conflicts can be more serious because of the closer relationship. If you have any questions, please feel free to call, comment below the video, try to answer those comments. And if you have any extra thing you want to add, feel free.